Listen to me very carefully, because I am Warren Buffett and I have spent my entire life making decisions based on preparation, information, and the disciplined refusal to walk into any situation without understanding exactly what the rules are and exactly how they apply to me. I have built more wealth than most people can conceptualize by doing one thing consistently: knowing what I own, knowing what protects it, and knowing precisely where my protection ends before I need. It's not after. What I am about to tell you has nothing to do with stocks or portfolios. It has everything to do with a Supreme Court ruling that just came down 9-0, the most unified decision on gun rights in a generation. If you carry a firearm in your vehicle and you do not understand what this ruling says, what it genuinely protects, and precisely where it will leave you completely exposed, then you are driving around with a false sense of security that is going to cost you in ways that make losing money look trivial. Stop the car. Watch this now. I have spent decades telling people that the most expensive mistake you could make is the one you were never warned about. This channel delivers the legal intelligence, the constitutional analysis, and the practical protocol that most gun owners will never receive until they are already standing on the side of a road wishing someone had told them. That information is worth far more than any consultation fee, and I am giving it to you completely free. The only price is a subscription and your commitment to be prepared. Hit that subscribe button right now, because the next ruling that changes your rights will not wait for you to find it in a red comment section 3 months after you needed it. Let me start with a story, because numbers in legal theory are only useful when you understand the human cost of not having them. A man with 40 years of responsible, law-abiding gun ownership behind him is pulled over for a minor traffic violation, not a serious stop, the kind of interaction that should resolve itself in under 10 minutes with a warning or a small fine. He has a valid permit, he has a registered firearm, he has done absolutely nothing wrong, not one thing in 4 decades of carrying. When the officer approaches his window, he does everything correctly. His hands are visible, flat, and still. He is cooperative from the very first second of contact. He discloses a legally owned firearm calmly, clearly, and without hesitation. No erratic behavior, no nervous sweating, no contradictory statements, no smell of anything, no evasive answers. By every objective measure, the traffic stop interaction is going exactly the way it is supposed to go, and the officer makes a decision. He decides the gun is enough. He concludes that the presence of a legally owned firearm, regardless of the valid permit, regardless of the impeccable 40-year record, regardless of the complete and total absence of any other indicator of criminal activity, justifies a full search of the vehicle. The driver objects calmly and clearly. He states explicitly that he does not consent to a search. The search happens anyway. The lower court sides with the officer, and they rule in writing, in a court of law, that under those circumstances, a legal gun, a calm driver, 0 other red flags, and an explicit refusal of consent, the presence of the firearm alone was sufficient legal justification for the search. 3 years of that man's life are consumed by the legal system. 3 years for doing everything right. I have watched businesses get destroyed by risks that were completely foreseeable and completely preventable. I have watched people lose fortunes because they walked into situations they did not understand without the information that would have protected them. This story is the same principle applied to your constitutional rights. The cost of being unprepared is always higher than the cost of preparation. Always. That is not a motivational phrase. That is the documented result of 40 years of watching people absorb consequences that should never have reached them. Now, I need to explain the legal collision at the heart of this story, because without understanding the structural problem this ruling was built to solve, you cannot fully understand what it protects or where its protection ends. The United States Constitution hands every American 2 foundational protections that are both completely settled and both supposed to be operating simultaneously every single day of your life, including on the side of a road during a routine traffic stop. The Second Amendment gives you the right to keep and bear arms. That right is not a privilege extended by the government at its discretion. It is not something you earn through good behavior or apply for through a government program. It is a constitutional guarantee exercised lawfully, responsibly, and without incident by more than 100 million Americans every single day. It is written as plainly and clearly as anything in our founding documents. The Fourth Amendment gives you something equally foundational and equally non-negotiable: the right to be free from unreasonable searches and seizures. No government agent can search your vehicle, your home, or your personal property without either a judicially authorized warrant or a specific legally defined justification called probable cause. That protection is not a technicality invented by creative defense attorneys. It is the direct product of the founders having lived under a government that searched homes and personal belongings whenever it felt like it, and deciding with absolute clarity that they would never allow that in the country they were building. Two rights, both crystal clear, both constitutional, both designed to coexist, and for years, quietly on roadsides across every state in this country, those two rights had been colliding in ways that most gun owners had no idea were happening until they were already in the middle of it. The legal reasoning being constructed in lower courts went like this: firearms are inherently dangerous. Therefore, a firearm present in a vehicle creates an inherently unsafe situation. Therefore, the officer has automatic authority to conduct a search regardless of whether any crime has been committed or even suspected. Follow that logic to its conclusion and you arrive at something the Constitution never intended and cannot honestly support. If the mere presence of a legal firearm gave law enforcement automatic search authority, then exercising your Second Amendment right simultaneously stripped you of your Fourth Amendment right. You could not have both. You were being forced legally, quietly, without public debate to choose between them. That is not what the Constitution says. That is not what any honest reading of the founding documents has ever meant. But it was happening in real courtrooms to real Americans, and it was spreading until the case that finally reached the Supreme Court changed everything. Here is what happened in that chamber, and here is why it matters more than almost any legal development for gun owners in the last decade. 9 justices, every ideological position on that bench represented the most conservative legal mind sitting alongside the most progressive, looked at the situation that man's 3-year ordeal had produced, and they deliberated. And they arrived at the exact same conclusion. 9-0. No dissents, no partial concurrences on narrow technical grounds, no ideological splits, no footnotes carving out exceptions for particular circumstances, a unanimous across-the-board ruling from the highest court in the United States of America. I want you to understand what that level of agreement means, because in my experience, when people who disagree on almost everything agree completely on something, it means the underlying principle is so clear, so fundamental, and so obviously correct that the disagreements dissolve. 9 very different legal minds arrived in the exact same place without hesitation, because the constitutional line being drawn. Was that clear? The core holding of the ruling is this: the mere presence of a legally possessed firearm in a vehicle does not by itself constitute probable cause to search that vehicle. Let me translate that out of legal language into plain practical English, because the plain meaning is what will protect you on the side of a road, not the technical phrasing. Legal gun ownership is not suspicious behavior. Lawful carry is not evidence of a crime. Law enforcement cannot treat either of those things as if they are. The court sent a direct, unambiguous message to every law enforcement agency in this country: you cannot use a citizen's exercise of one constitutional right as your justification for stripping them of another. The Second Amendment and the Fourth Amendment are not in competition. They coexist. A law-abiding gun owner is entitled to both simultaneously, without condition, without being forced to sacrifice one to exercise the other. Armed does not mean criminal. 9-0. That is a powerful ruling, and it deserves to be understood and respected. But here is where I need you to pay the most careful attention, because this is where the financial parallel becomes exact. A protection you do not fully understand is not a protection. It is a liability. An investor who buys a stock without understanding the risks built into the position does not have an investment. They have an expensive problem waiting to announce itself. This ruling has 3 specific vulnerabilities built into it, 3 places where the protection stops, and you need to know all 3 of them cold before you ever need them. The first vulnerability is absolute and non-negotiable, and it applies before anything else in this analysis. This ruling protects people who are legally entitled to possess a firearm. It does not extend 1 inch of protection to prohibited persons. If you are legally barred from possessing a firearm due to a prior felony conviction, a domestic violence restraining order, or any other disqualifying legal factor, the gun in your vehicle is not a neutral detail. It is evidence of a crime actively in progress. This ruling has zero relevance to your situation, and attempting to invoke it will make your legal position significantly worse, not better. Furthermore, if an officer has any reasonable articulable suspicion that your specific firearm is not legally possessed, even if you genuinely believe it is, the analysis changes immediately. The suspicion of unlawful possession is itself the probable cause the officer needs. This shield only functions when your legal status is completely and verifiably clean. Any legitimate question about your right to possess that firearm, and this ruling does not apply. This is not a gray area. It is the foundational boundary of the protection, and it cannot be negotiated around. The second vulnerability catches responsible, well-intentioned, genuinely law-abiding gun owners who simply did not do their homework. And it is entirely preventable, which is what makes it the most frustrating category of legal exposure I can describe to you. Many states have specific statutory requirements governing exactly how a firearm must be stored inside a vehicle. Some states require the weapon to be unloaded. Some require it to be secured in a locked container. Some restrict which part of the vehicle it can be located in. These are not obscure regulations buried in legal fine print that only specialists know about. They are criminal statutes, and violating them is a crime. If an officer approaches your window and observes a firearm stored in direct, visible violation of your state's specific storage law, the 9-0 ruling will not help you. The officer is not searching based on the presence of a gun. He is searching based on specific, observable, but articulable facts indicating an active violation of a criminal statute. The gun is legal, the manner you are storing it is not, and that distinction, which sounds like a minor technical difference, is the entire difference between this ruling protecting you completely and this ruling having absolutely no relevance to your situation. Know your state's firearm storage laws before you put the car in drive, not as a suggestion from someone being cautious, as a requirement from someone who has watched preventable mistakes produce devastating consequences for decades. The third vulnerability is the most nuanced, and it is where genuinely innocent, completely law-abiding people get caught. The ruling stops officers from using a legal firearm as the sole justification for a search. It does not stop them from using it as one factor among several. Picture this. You were pulled over, you have a completely legal firearm, your permit is valid, and your record is spotless. But your passenger is visibly nervous and giving contradictory answers to basic questions. There is an unusual odor in the vehicle. You are providing inconsistent information about your destination. In that situation, the officer is not going to argue in court that he searched your vehicle because of the gun. He is going to argue that he searched because the gun, combined with the passenger behavior, combined with the smell, combined with the inconsistent statements, collectively established probable cause, and he may be legally correct. The Supreme Court did not abolish the automobile exception to the Fourth Amendment. What it stopped specifically and precisely is the use of a lawful firearm as the only justification. Everything else at that stop still matters. Every other observable factor can still be used. Your behavior, your passenger's behavior, anything visible in the vehicle, any odor, any inconsistency in your statements, all of it remains legally available to an officer building toward probable cause, and the gun alone cannot be the justification. The gun plus anything else is a different legal question entirely. Understanding where a protection ends is as important as understanding what it covers. In 40 years of investing, I have never lost serious money on a position I understood completely. I have occasionally lost money on positions I thought I understood. The difference between those two outcomes is always the same: the depth and accuracy of the preparation going in. Now, I want to give you the complete practical protocol. 8 specific steps from the moment those lights appear in your rearview mirror to the moment the stop ends, because information without action is just expensive entertainment, and I have never believed in expensive entertainment. These steps are not theoretical positions derived from legal philosophy. They are practical, concrete, sequentially ordered actions built around the realities of how traffic stops actually unfold, and how the legal consequences of those stops are actually decided in courtrooms. The first step is to pull over immediately and correctly. The moment you see those lights in your mirror, signal, reduce speed smoothly, and move to the right shoulder without any hesitation, delay, or ambiguity in your movement. A slow pullover, an uncertain pullover, or any movement that could be interpreted as evasion creates tension and suspicion before the interaction even begins. Tension is the enemy of a clean stop. Remove it before it starts by demonstrating immediately and unambiguously that you are fully cooperative. The second step is to control every environmental variable in the vehicle before the officer reaches your window. And this step has more impact on the tone of the entire interaction than most gun owners realize. Turn off the engine completely and roll the driver's side window fully down. If your vehicle has tinted rear windows, roll those down as well. Visual uncertainty through tinted glass makes officers approach with heightened alertness before they have exchanged a single word with you. If the stop occurs at night, turn on your vehicle's interior dome light so the officer can see clearly into the cabin from a distance. Then place both hands flat on top of the steering wheel and keep them there, visibly still. Before the officer reaches your window, do not reach for your registration. Do not reach for your wallet. Do not adjust anything in the vehicle. Do not move your hands from the steering wheel for any reason until the officer is at your window and you have verbally communicated to him exactly what you are about to do and where you are about to reach. The third step is to speak before you reach for anything, and this is the step that most gun owners get wrong, and the consequences of getting it wrong can be severe and instant. When the officer asks for your license and registration, your instinct is going to be to immediately reach for your documents. Do not do that. If your firearm is located anywhere near your document storage areas, and in most vehicles, the glove compartment that holds your registration is within reaching distance of where firearms are commonly stored, and unannounced hand movement toward that area is precisely how a calm, routine interaction escalates into something else entirely before either party has processed what is happening. Before you move your hands anywhere, speak. Inform the officer clearly, specifically, and without elaboration that you have a legally owned firearm in the vehicle, that you want to cooperate fully with every part of this stop, and ask how he would like you to proceed in retrieving your documents. That single approach accomplishes three critically important things simultaneously. It demonstrates complete, proactive, voluntary cooperation. It eliminates the element of surprise entirely, and it places the procedural decision in the officer's hands, communicating without ambiguity that you are a responsible, protocol-following, safety-conscious gun owner, not a threat, not a problem, not someone attempting to conceal anything. The fourth step requires homework you must complete before you are ever in the situation. Because you cannot learn it at the window, know your state's duty to inform law before you drive. Some states legally require you to inform a law enforcement officer immediately and automatically upon contact that you are carrying a firearm. Others have no such requirement. This varies by state. It varies in its specific requirements, and it matters enormously to how your interaction must proceed from the first to second. If your state mandates disclosure, comply immediately and without elaboration the moment the officer reaches your window. Do not wait to be asked. If your state does not require disclosure and the firearm is not visible, you have no legal obligation to volunteer that information unprompted. But if you are directly and explicitly asked whether there is a firearm in the vehicle, understand this with absolute clarity. A single lie to a law enforcement officer can transform a routine traffic stop into a criminal matter faster than almost anything else that can happen at that window. The fifth step is the most legally critical moment of the entire stop, and I want you to understand the psychology of it. Before I give you the language, because understanding why this moment is so psychologically difficult is what will allow you to navigate it correctly under pressure when the officer asks if he can look inside your vehicle. And you may ask this at any point during the stop. Every cooperative instinct you have as a law-abiding citizen is going to tell you to say yes, to prove you have nothing to hide, to demonstrate your good faith by opening up completely That instinct is understandable. It is human, and following it will hand the officer a blank check to search every inch of your vehicle. Your response is simple, it is brief, it does not require explanation, and it does not require apology. You do not consent to searches, that is a complete response. Do not argue constitutional law on the roadside. Do not cite this ruling or any other ruling. Do not explain your reasoning or justify your position. Do not apologize for your answer. Simply state that you do not consent and then stop talking. The moment any version of consent, any agreement, any sure, any go ahead, any I don't mind, leaves your mouth, the 9-0 Supreme Court ruling becomes completely irrelevant to your situation, and you have voluntarily handed that officer the authority to search everything. Consent overrides the court. This is not a nuance buried in legal footnotes. It is a foundational principle of Fourth Amendment law. Voluntary consent to a search constitutes a legal waiver of your Fourth Amendment protection, and that waiver cannot be undone in a courtroom, not with this ruling cited, not with the best defense attorney money can buy, not with video evidence of every second of the stop. Once consent is given, it is over. The sixth step is a deliberate and strategic use of silence. And I want you to understand that silence is one of the most powerful legal tools available to you at a traffic stop. It is a protected exercise of your Fifth Amendment rights. It costs you nothing, and most people squander it completely by filling every quiet moment with nervous, volunteered explanation that they were never asked to provide. Do not answer questions like, "Where are you headed tonight? Is there anything else in the car I should know about?" Or "Why are you in this area?" unless you choose to.